Okay, we can go ahead and get started. Welcome and thank you for joining Seyfarth's webinar, Top Labor and Employment Issues and Disruptions for the Midwest Transportation and Logistics Industry. All participants are in listen-only mode. You are encouraged to submit questions throughout the program using the Q&A feature located on the right side of your WebEx window. We will do our best to get to everyone's questions. However, if your question is not answered, our presenters will follow up with you directly in the days ahead. For those interested in CLE credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and it is required for CLE credit. Copies of the webinar recording and materials, as well as the CLE verification form, will be distributed to attendees following the presentation. At this time, I'd like to turn the program over to Erin Foley. Erin, you may begin.
Good morning, everyone, and thanks everyone for joining us on this beautiful sunshiny day here in Chicago. We have a great presentation for all of you this morning. We are a little bit focused on the transportation and logistics industry this morning, but I think a lot of this is going to be applicable to any number of our clients, and thank you all for participating this morning. Next slide, please. There's our disclaimer. We've got a great group of speakers for you this morning. Pleased and proud to be able to present all of them to you. We're going to kick it off this morning to Patrick Joyce, but before I do that, I do just want to remind everyone about the Q&A. I'm going to be monitoring that during the course of the program. We will hold the questions until the end, but certainly we will try and get to them, and we're going to try and leave about 20 to 30 minutes for a Q&A, so please feel free right early, right often, because we're happy to try and get those questions resolved for you. So without further ado, I'm going to kick it over to Patrick, who has recently relocated to Seattle, but because we can never actually let him go, we're going to have him here always with us in Chicago, and Patrick is going to kick us off with the health and safety portion of our programming this morning. Thanks everyone again for joining.
All right, thank you very much, Erin, and I'm looking forward to getting these back in person, although as Erin said, I'm in Seattle now, so I'll probably still be remote, but I'm looking forward to getting back in person, but I'm happy that you are all able to join today. You've all been in kind of a unique situation in transportation and logistics, because not only do you have to comply with, and I do health and safety and OSHA work mostly, not only do you have to comply with the OSHA side of things when you're, say, at a customer's facility, picking up or dropping off delivery or something like that, or at a terminal or an endpoint, you also have to comply with the specific regulations for your particular industry while you are out in between destinations. So that's made the COVID pandemic, from what I understand, a bit more tricky to navigate from a health and safety perspective for the transportation and logistics folks. And to add to the fun, each individual city and jurisdiction, as you go through it, or maybe as you make a stop, has its own unique requirements. And this makes it a very difficult situation to navigate all of those. Luckily, as I'll talk about here, those are starting to be pulled back, and the world is, as we have been hearing a lot, the world has been reopening, although maybe a little slower than some of us want. Next slide, please. So due to the nature of your operations, you haven't really had a chance to stop and pause and really think about what's been going on. It's been go, go, go from the very start. And there's been, your employees have been in situations where there are maybe a hot spot as you're making a delivery or doing a pickup. And as consumer goods and leisure traffic started to go away, emergency transportation, emergency goods became even more important to transport these critical goods and supplies, medical goods, food, household goods, that type of thing. Because of this, as I said, your employees were going into these hotspots. So you've had to comply with the various regulations that I was talking about. Although while you're at a particular location, OSHA is in effect. While you're in between, you have the various DOT and FRA, FRSA laws that you have to comply with. As we all know, OSHA does not have any specific regulations when it comes to infectious diseases or even the COVID-19 pandemic. There was talk of it happening. It didn't end up happening for the general industry folks. But there still is, and this is still a consideration as things continue to open up, the general duty clause, where if there's a recognized hazard in a particular industry, COVID-19 is a recognized hazard, you have to take the feasible means to protect your employees from those hazards. So say you're dropping off at a distribution center or you're picking up at a distribution center. If you are at a particular customer, they may have requirements such as screening, masking, distancing, things like that, that you need to make sure your employees comply with so that they stay safe while they're at that facility. There's also some issues when it comes to what the feasible means of abatement are. And when it comes to OSHA speak, really that means following the guidance. And in this case, that's been CDC guidance. OSHA has put out some guidance and things like that. So make sure you stay with the guidance that's coming out, even as it's starting to relax. Another situation is oftentimes you'll have employees that are sharing spaces. A lot of jurisdictions have addressed this specifically and put out requirements for sharing spaces, including DOT. I've seen regulations from other agencies as well, requiring masks while in the vehicle, requiring windows to be rolled down, requiring the air conditioning to be going on full speed, that type of thing. Some of these, again, are starting to be relaxed, but make sure you stay vigilant as the pandemic continues to wind down, especially when you have employees that are in the same space as each other because they're in close contact for a long period of time. There's another situation that will be talked about later in more detail, but when employees raise concerns about potential exposure to COVID-19, they come to you and they say that they're afraid to return to work, they're afraid to go to a particular location or area. You have to take those concerns seriously, because obviously we've been in this pandemic for quite a while. Any sort of complaint about health and safety, either to you or to a regulatory body, has to be taken seriously. And these employees are protected by, the various statutes that are out there, Air 21, SCAA, those types of things, the whistleblower provisions. And that'll be, as I said, that'll be talked about later in terms of the particulars, but make sure you take those seriously and that you don't do any sort of retaliation for any sort of complaints that may be made or concerns that may be raised. There's one unique thing that as I was doing research for this, that I found that in the airline industry specifically, there was an alert that came out about some unique issues presented by the regular application of alcohol-based sanitizers, that they're starting to find that the materials are drying out and becoming brittle and cracking. So make sure you pay attention to those types of things as well. There's way too much for me to get through in the small amount of time I have. But one of the other things that has come up is there have been various emergency rules, both on the side of making things more narrow and broadening out requirements. For example, hours of service emergency declaration, which allows folks who are transporting critical materials to, reduce the impact of the hours of service rules. And then on the flip side, the mask requirements for the public and public transportation is still in place. It's set to stay in place until September. It may be removed prior to that, but you have to keep in mind that in that situation, the vaccine requirements, the exemptions do not apply, at least from the TSA and those other agencies. All right, next slide, please. So I briefly talked about the OSHA Emergency Temporary Standard, and we thought this was coming for general industry. It turns out it was only issued for the healthcare industry. There's no emergency temporary standard that is expected for general industry from federal OSHA. As you may know, even though we're focused on the Midwest in this call, California, Virginia, Oregon, and Michigan, which is the Midwest, have issued their various emergency temporary standards. So if you have any particular questions about that, please let me know and I can help you with that. Some of you may transport goods into a healthcare setting. And if that's the case, you may be covered while you're at that facility. You may be covered by the OSHA Emergency Temporary Standard for Healthcare. So again, contact us if you have any questions about that. In conjunction with the ETS, OSHA issued some guidance for general industry. And while there is nothing that is specific to transportation and logistics, the various industries where you make deliveries or you have terminals or endpoints, they are covered: retail, meat and poultry, agriculture, to name a few. So be sure that you pay attention to that guidance while you're at a customer facility doing those deliveries or pickups. There's really nothing new that we haven't heard in that guidance other than the fact that there's a lot of discussion about exemptions for fully vaccinated individuals and some other tweaks here and there. All right, next slide, please. So looking to the post-COVID world, I often get asked if I have a crystal ball, which is why it's appropriate that this graphic is here. It seems like disruptions to the various industries are starting to be pulled back, and the various jurisdictions are starting to drop requirements. We've heard a lot about reopening. New York, California, Illinois just reopened on Friday. Michigan is going to reopen on July 1st, according to the governor. And while reopening is happening, this doesn't mean you can just throw a caution to the wind and just go back to life as normal. You still have to keep in mind all of those considerations I talked about with the general duty clause, keeping your employees safe and healthy. Really, when it comes to that, masking for unvaccinated and screening are the best ways to achieve that, because think about it. If you screen, you're going to keep the person out of the workplace, and any of those other mitigations are not going to be really necessary if the person isn't sick in the workplace. Finally, something that we're seeing, especially in retail and in the airline industry, is that masking requirements are starting to lead to some workplace violence concerns. We've seen all the videos about flight attendants who are just trying to do their job being assaulted and injured by customers who don't want to wear masks for whatever reason it may be. So one of the key considerations as we're starting to come out of this, but some things remain in play, is to keep your de-escalation training up to date for those who may be interacting with people who could get violent. Take advantage of programs that are out there, and we can help you identify some areas that training can be done in, and really just focus on keeping your employees safe and doing the good work that you've been doing. And thank you very much for all the work you've been doing keeping this country running. That's my time. Thank you very much for paying attention and listening. And now I'll hand it off to Carla Sanchez, who's going to be talking about organizing and hiring.
Hi, good morning, everyone. Thank you for joining us. I will be covering briefly four main topics. The first one is, why is this a hot topic for all of y'all organizing under the NLRA and RLA? Two, just a brief refresher on organizing the process under the NMB and the NLRB. Three, things to consider doing now in anticipation for any potential organizing efforts in the future. And finally, as we get ready to reopen or start reopening, we're all facing hiring issues. If you have an organizing group of employees or are undergoing an organizing campaign, what are those things that you should consider? So with that, I'll get started. Next slide, please. All right, so why is this a hot topic for the transportation and logistics industry? Well, as we all know, we have a new administration. President Biden has had some initiatives, has made remarks that it give us the indication that he is going to be a very pro-union president. Some have considered him to be the most pro-union president in recent history. In late April, President Biden issued an executive order establishing the White House Task Force on Worker Organizing and Empowerment. And this task force, its goal is really to find ways to encourage organization, to encourage unionization, and to increase that. As soon as he took office, though, we saw a drastic change. He immediately fired the general counsel for the National Labor Relations Board. That had been Peter Robb, and his term was set to expire at the end of this year. He fired him in January and replaced them temporarily with Peter Sung-Orr, who was the regional director for Region 13 here out of Chicago. We expect that Jennifer Abruzzo will be the general counsel. Currently, she's going through the nomination process, but Jennifer Abruzzo has a union background. She worked for the CWA, the Communication Workers of America. So we're seeing a change based on who President Biden is selecting. On the NMB side, the National Mediation Board, we're also seeing similar changes. He has appointed Deidre Hamilton to the NMB. The NMB is made up of 3 board members. So now we have Deidre Hamilton as a person who also has a union background. She was a staff attorney for the Teamsters on the Airline division. So we're seeing those changes from President Biden. We're also seeing expect the board composition from the NLRB to change in the next few years. As you all know, the NLRB is comprised of 4 board members, currently, or 5 board members. Currently, there are 4. So President Biden will be nominating 1 board member, and William Emanuel, who is a Republican board member, his term is set to expire in August of 2021. So by the end of this year, there will be 2 openings which President Biden will be able to appoint, making the board 4 Democrats to 1 Republican. And the board for the National Labor Relations Board, they issue many decisions that affect employers with respect to how organizing drives are handled, what are the things that they can and cannot say to employees. So these changes that we see based on the administration are really going to impact all of you transportation and logistics employers. Other than the new administration, though, there's something else that is up in the air right now with respect to legislation, and that is the Protecting the Rights to Organize Act, the PRO Act. I won't go into too many details about this act, but I will highlight some of the things that would affect you from an organizing standpoint. So one of the things that the PRO Act, and it's a legislation that has passed the House already, it's currently with the Senate, and we're trying to see what happens there, but assuming that it passes and it passes the way that it currently is drafted, this would be a very drastic change to employers. It would codify the quickie election rules that were introduced under the Obama board, and the quickie election rules would essentially give you 13 days from notice of a petition that was filed with the NLRB to the election. So less than 2 weeks you would have to campaign to figure out what the issues are, to meet with your employees, to organize a drive. So as you can imagine, 13 days is not a lot of time, and that would be codified under the National Labor Relations Act. The PRO Act also wants to have some codification of small units, making it easier for unions to organize very small micro units. So for example, you could have a unit at a Macy's that includes only the kids' shoe department. They could be organized by one union, and then the male shoe department would be organized by a separate unit or a separate union altogether. So it would make it easier for unions to hand pick who they have that supports them, and to slowly take over your industry, take over your various departments by getting in within small groups and then slowly building on that. The PRO Act would also prevent captive audience speeches. So these are the speeches that when you're undergoing an organizing campaign, you want to have with your employees, you invite them into a conference room and you educate them on what unionization would mean to them. Well, unions are trying to prevent you employers from doing that, and the PRO Act would prohibit it, making it unlawful for you to have these massive meetings with your employees. Another thing that would happen with the PRO Act is that it would eliminate your right to have any kind of power during strikes. so you wouldn't be able to permanently replace your employees. During a strike, you're able to continue operating your business, but one of the threats that you have in your power is to tell employees, look, you can strike for as long as you want, but we have a business to run, and if we have to permanently replace you, we will, which means that if you choose to strike for years, that's on you, but you might not come back. Well, the PRO Act would prohibit you from doing that. You would be able to continue running your business, but as soon as your employees would want to come back, you would have to bring them back to work. So obviously the power you have over trying to shorten a strike or eliminate a strike altogether disappears with the introduction of these restrictions on you. It would also prevent you from having lockouts. I know lockouts are not very common these days, but that is the tool that employers have, locking out your employees, and especially in the logistics and transportation industry. This is important because of the safety concerns. And you wouldn't be able to do that. You would have to continue to operate your business irrespective of the concerns that you would have with respect to your employees. One last thing that I'll highlight here that the PRO Act would do is that it would mandate interest arbitration for first contract. So currently under the NLRB, you can take as long as you want to bargain a contract. Sometimes contracts are not reached at all. And a mediator, while they can be welcome at the bargaining table, it requires both sides at the table to agree to a mediator. This is unlike the NMB where a mediator usually gets involved. But from the NLRB standpoint, this is a huge issue because you would be forced to engage in interest arbitration, meaning that an arbitrator would ultimately decide the terms of your contract if you cannot reach within a certain period of time at the bargaining table for a first contract. So these are major changes that we should all be careful about and consider now because it will impact you with respect to organizing in the next 4 to 8 years, depending on how long President Biden's in office. So let's go on to the next slide, please. So I've talked a little bit about administration issues and also current legislation that might impact you. I also want to highlight that we are seeing some efforts by unions to organize in this area. So we have the Teamsters 2021 convention coming up, and as part of the convention, the O'Brien-Zuckerman team has announced several resolutions, 5 resolutions in total, and out of those two are in this space. They are seeking to organize Amazon, and they're also already looking at the UPS contract for 2023. Their latest contract had many issues. A lot of UPS employees were unhappy with the contract, the way that the vote happened. And so the Teamsters are already preparing for that contract. In addition to that, the Teamsters for the last few years have been trying to organize XPO throughout the United States. XPO is the second largest logistics company in the US. And so Teamsters, what we're seeing is that in this space, they are trying to organize various transportation and logistics companies. On the NMB side, we're also seeing something similar. Prior to COVID-19, we had the flight attendants for Delta. They were trying to organize the FAA, which is the largest attendance union, was trying to organize them. That has halted, but we expect that as things get back to normal, that the Delta flight attendants will again try to organize. As it is now, they are the largest group of flight attendants that remain unorganized in the United States. Next slide, please. So given the issues that we're seeing in this space, I want to just give a brief refresher of the general election process so that you know what you're facing in terms of a timing if you're facing an election with the NLRB or with the NMB under the RLA. So under the NLRB, there is a requirement of a 30% showing of interest for a union or an employee to reach out to the NLRB and seek an election. This is easy to do. It's 30% of whatever group the union is trying to organize. It doesn't have to be by department. It doesn't have to be by facility. It's just based on the group that it's trying to organize. And as I mentioned, the PRO Act would make it easier for unions to organize even smaller, more discrete groups. So 30% is what is needed. This is a showing of interest, which is usually a note card size piece of paper that unions just pass around, employees might pass around to their colleagues or coworkers and just ask them to sign. It's a very basic form, doesn't require much information beyond name, address, phone number, and a signature. I will say that most unions will not go to the NLRB with only a 30% showing of interest. In order to win an election, they need a majority of the votes of the people that vote. And so 30% doesn't get them the win. They would rather spend the time on getting more cards, getting more votes on their side before they go to the NLRB. And in most cases, we expect they at least have 70% of the bargaining unit cards from that 70%. Similar in the RLA space, the requirement there is 50%, so it's 20% more than in the NLRB space. But as I mentioned, from the NLRB standpoint, you're usually getting that 50% plus. And to note on the RLA front, you need a showing of interest system-wide of the craft or class that you are trying to represent. So slightly different, but at the end of the day, both sides, unions are going in with more than 50% when they're trying to seek an election. Now, with both agencies, the NLRB will determine the appropriate bargaining unit, and on the RLA side, the NMB will determine the appropriate craft or class. It's easier, I would say, on the NLRB side to determine the appropriate bargaining unit, because if the employer doesn't oppose the bargaining unit, usually the board won't do anything and just proceed to an election. On the NMB side, there is more an investigation, and investigators assigned to the group, and the investigator controls the investigation, determines whether the unit as proposed is appropriate, and moves forward with selecting the logistics of the election. Now, under both, there is a short turnaround to an election. As I mentioned, the PRO Act would shorten this on the NLRB side to 13 days. But currently what we're seeing is that from the filing of a petition to the election, it's about a 3-week period, 21 days being generally the norm. On the RLA side, it's usually 3 weeks, sometimes more, depending on the complexity of the election, because these tend to be larger elections. It might take longer. Investigators also have more control over determining what they need to proceed to an election. It's very common for the investigators to seek information, to ask the employers for information as part of their investigation, and so it might take longer. Employers also on the NMB side can request for extensions of time even after an election has been set. So there's a little more wiggle room on the RLA side than the NLRB side, but still we're seeing about 3 weeks or so on both sides. The elections are conducted a little bit different on both. So with respect to the NLRB, currently elections are being conducted via mail. That will change as we start opening up. The NLRB's preference is to have manual elections, and those are in person. And on the RLA front, they're usually via telephone or the internet. So employees will be mailed a packet with instructions. They will receive a special code, each employee receiving a code, and they can choose whether to call in and vote or to access the internet, their website, and to enter that information and to vote. They're given about 3 weeks to decide when they want to vote. So under both, it's a very easy process. It's confidential how employees vote, but that's generally the regular election process. What I want the takeaway here to be is that under both, you're looking at a very short window of time. If you're an employer facing an election, you probably have 3 weeks or so to determine who's going to be a part of the bargaining unit, how you conduct a campaign if you choose to have a campaign, whether or not you want to hire persuaders, and you have a very short window to convince your employees to vote no to the union. So let's move on to the next slide, please. So given this short window, here are some things that you should consider right now that you're not undergoing an election, hopefully. So don't wait for a petition under the NLRB or an application under the NMB. Figure out what you need to do now. Assess workforce issues and vulnerabilities. Determine whether there's things that you control now. If employees are complaining to you, they're reaching out with respect to various issues, this is a time to try to figure out what those issues are. Perhaps there's a manager that employees are complaining about. Most of the times, I would say that when you get an election, it's either because employees are unhappy with your benefits or they're unhappy with your management team. Sometimes terminating the manager, the supervisor, is all that is needed. And right now that you don't have an existing petition, existing application, this is the time that you can make that change. Determine whether your management team needs some kind of training, or whether you need to terminate people and decide to create a different style of a management team, or to rearrange your management group. If the benefits are the issue, this is also the time to determine whether you can make changes to your benefit. Sometimes simple changes make a big difference to employees. But just don't wait until you get that petition or application. Assess now your work issues, your vulnerabilities, to the extent that you can. Also, to the extent that you can, make these changes now. Understandably, this is a hard time for everyone, and it might not be possible, but making some changes sometimes discourages unionization. Also, talking to your employees, explaining to them why you can or cannot make the changes is important. Sometimes communication it's what's missing. It's why they think that their supervisors or managers are the problem. But if you communicate to the employees, sometimes that discourages unionization. If you can make the changes, this would be the time, because as most of you know, if you are undergoing a unionizing campaign, you cannot make any changes during that time. You have to keep things status quo. So making these changes now would be recommended. And then finally, have a plan in the event you get a petition or application. Know who would be your key supervisors, your key managers to organize the campaign, be your speakers to the employees during that period of time. Figure out if from an HR standpoint, you need to obtain information to be able to handle a petition or an application. From the NLRB side, you must produce a list of voters within a very short window after you get a petition, and that list has to include employees' email addresses, other personal information that is sometimes not easily attainable. And we as employers have an obligation to go to all the managers and supervisors and collect this information, go through I-9 forms and other HR forms and gather that information. And if you don't, that could be a reason why an election result is turned over and you have to go through a rerun election. So being able to prepare for a petition and application in advance is very important, given the short period of time that you will have once the petition or application is filed. Let's go on to the next slide, please. All right. So now I just want to talk briefly about some hiring issues, on-demand hiring issues that you might be facing. As we start to reopen, we're all hearing that there's issues with hiring. We're not finding qualified employees. I've had clients that can't hire enough CDL drivers. They just keep posting, but they can't get sufficient employees. And so you might be wondering, well, what is it that I can do now to hire the people that I need to run my business? Can I use temporary help, contractors, on-demand employees? And the answer will be, it depends. So if you are under a collective bargaining agreement, you need to look at that CBA. You need to determine whether there's language in your CBA that addresses temporary workers, contractors, seasonal employees, other types of employees. If there is, you need to see what that language says. I would say that most contracts have language allowing for the use of temporary workers, contractors, but under very small circumstances. And sometimes those are enumerated, sometimes there's not, and you're going to have to consider what past practice you've had with respect to hiring outside help. If your contract doesn't have that kind of language, look at your management rights clause. Sometimes your management rights clause is drafted broadly and could encompass the hiring of temporary workers or other workers. Again, you have to look at the language of your contract. If what you're trying to do is maybe change the terms and conditions of employment to try to encourage more people to stay on, or to have an easier time recruiting new people, you need to look at your contract to see if changes are allowed. Most contracts cover wages, hours of work, benefits, and there's language that says that these benefits cannot be changed during the contractual period. So you have to see what your contract says about that. If it has that kind of language, then you might be stuck with those terms. If it provides for some discretionary language, so sometimes you'll have language that says this is a minimum wage that you can provide, but on your own discretion, you, the employer, can pay more to the employee. If you have that kind of language, then you might be able to provide different incentives, different bonuses, or a different kind of pay to recruit more people to the bargaining unit and to maintain your current employees. So the focus here is to look at your contract, see what you can do within the terms that you have already bargained. Now, let's assume that the contract language doesn't help you and you still need to make changes to be able to continue to recruit. One thing you can do is to bargain during the period of the contract. There is nothing preventing you from going to the union and saying, look, we have a contract in place. I know that the terms have already been bargained for, but we are under unprecedented times and we need to bargain over temporary or permanent changes. If the union doesn't want to bargain over these changes, then you're stuck with whatever the CBA says. But if you're willing to pay more, if you're willing to provide benefits or changes that are going to be beneficial to your existing bargaining unit members, the odds are that the union is going to agree to bargain over these and to agree to the changes that you're proposing. So there's nothing preventing you from reaching out to the union and trying to bargain something that's better than what you previously bargained with them. Now, if you are bargaining currently your first contract, meaning that you don't have a contract in place, or you are undergoing organizing efforts by a union, you must maintain the status quo. That means that you can't make changes to your wages, to your benefits. You must keep everything the same. The only exception to that is if you have a plan to change the terms and conditions of employment. And that means that before you had knowledge of the organizing effort, or before you had knowledge of the union that's already in place and that you're bargaining the first contract, before you had knowledge that they were going to be trying to represent the employees, you had planned a change, and you can articulate that change and the date that that change was supposed to kick in through written record. If you can prove that, then you can go ahead and change the status quo. But absent that, you're going to be stuck with the same terms and conditions of employment until you reach a first contract during negotiations or until the organizing drive ends. The only other thing I would say about this is that obviously if you're bargaining your first contract, you can try to reach an agreement with the union to have some temporary changes made. And so long as the union agrees to those, you can bargain those separately and continue bargaining for your first contract at the same time, simultaneously, but just getting some terms to help you out with the hiring issues you might be facing currently. So that's all I have for now. I am now going to pass it to Matt Gagnon, who is going to talk about COVID-19 related litigation issues.
All right, thank you, Carla, and good morning, everyone. Thank you for being here. I'm a partner in the Chicago office, and my practice focuses on employment litigation, especially class and collective actions. And so what I'd like to talk about today is to give you an overview of COVID-19 related litigation, and especially how that litigation is impacting the transportation and logistics industry groups. So since the very beginning of this pandemic, Seyfarth Shaw has been tracking and categorizing COVID-19 related lawsuits, and we've now developed I would say a very comprehensive database of those cases. And that's where I'm going to be pulling a lot of the information that we have today. And I know that there are some other firms out there or some other organizations who are doing this, and all I can say is that it's more art than science. We've grappled with these issues internally, and I think that we have compiled what I would consider to be the top line database on these issues across the country. Let's go to the next slide. All right, so what are we talking about when we talk about COVID-19 litigation? Well, we have found that those cases typically fall into these 5 buckets. So one is a failure to provide a safe working environment. So these types of cases are usually asserted under some state version of a negligence claim. A common set of allegations that you would typically see is that an employer has failed to provide workers with adequate PPE, or a failure to implement customer or visitor policies, such as temperature checks, masks, etc., that would protect employees. Far and away, these types of claims are the most common, what I would call COVID-19 related litigation claims. Second, you have discrimination claims. We've seen a noticeable uptick in age and disability discrimination claims that are tied to the COVID pandemic. And those can often be paired with a safety complaint or a leave claim. where plaintiffs allege that they were denied accommodations due to pre-existing medical conditions that make them more susceptible to COVID-19 complications. So I'm thinking about a recent case. The fact pattern was that this person had moderate asthma and had been allowed to work from home for a period of time, but then after a while was brought back into the office and alleged that the refusal to allow her to continue to work from home was a failure to accommodate under the ADA. She had moderate asthma. Ordinarily, a court would probably not hold that rises to the level of a disability under the ADA, but what we've seen, and in this case, the court said that in the context of COVID-19, where that type of disease is going to give rise to greater complications with COVID-19, then this does rise to the level of disability under the ADA. And therefore the employer having even given PPE, a KN95 mask, implemented other policies and procedures, still was at fault for not going through the iterative process that the ADA requires when you're talking about reasonable accommodation. Leave claims. A large number of lawsuits continue to be filed alleging that employers have been unlawfully denied sick leave or family and medical leave for reasons related to COVID-19. And there were a patchwork of laws there under the Family Medical Leave Act, the Families First Coronavirus Response Act, and other state and local paid leave laws that were relied upon to make out those causes of action. But in general, it's either that person, him or herself, or a family member has contracted the disease, some time needs to be taken, and employers' reaction to that can generate leave claims. Retaliation and whistleblower claims. So frequently, these lawsuits allege that an employee was terminated because they complained about workplace safety or working conditions, including complaints about failure to provide appropriate PPE, or failure to comply with applicable COVID-19 safety protocols. And as you know, and we'll talk a little bit more about this later, but employers know those have been shifting. It's been a constantly shifting environment over the past year. And how has that played out in the case law? That's something that we're tracking very closely. Wage and hour claims. Wage and hour class and collective actions continue to be filed at rates that are pretty similar to before the pandemic. Quite honestly, there haven't been that many wage and hour theories that are directly related to the pandemic. An example or a counterexample to that general statement would be that we've seen some cases where they've alleged that, sort of similar to these security check lawsuits, where is it compensable time to require employees to go through a temperature check line or something of that nature. So we've seen a few like that. By and large, however, what we see is that these wage and hour lawsuits, to the extent that they relate to COVID-19, are typically using a business disruption, reduced hours, that kind of thing, as the impetus for a wage and hour lawsuit, rather than something that's more directly, I think, tied to the pandemic itself. And so I would say wage and hour claims have not been the driver of COVID-19 litigation that I think we had expected to see a year ago. Let's go to the next slide. Okay, so based on our analysis of the case filings, we've seen that most cases have been filed in California and New Jersey, and other states that lead the pack are Florida, Ohio, and New York. These are some big population centers, so it does make sense. The types of claims that are filed in those states are pretty similar to the other states. We have not seen a great disparity in terms of the types of cases filed in particular states. Like I said, among all of the case filings, the workplace safety and the retaliation claims that come with that, complaining about workplace safety issues, are definitely the most common. And I think that if I could talk about one trend in that area, is what I mentioned previously, is that courts have been aware of and have been allowing some discretion on the part of employers for how they deal with those issues, given the changing understanding of the pandemic over time. And so I'm thinking about a recent case And, so I think this one gives you an idea of how these fact patterns develop. An employee alleged that she had been compelled to resign from her position, so a constructive discharge claim, due to her employer's failure to maintain a safe working environment. So this is a claim under state tort law. I think it was a California case. The court noted that in fact, the plaintiff was working in what it called a congregate environment at the height of the novel pandemic that was killing thousands of people, and so was sympathetic to that claim. But nevertheless, and allowed the claim to proceed, but the reasoning here is important. The court held that given the novelty of the coronavirus at the time of plaintiff's resignation, scientists and medical professionals were struggling to provide clear guidance on how best to protect against it. As a result, the guidance provided at local, state, and national levels by appropriate medical authorities and political leaders was confusing, if not conflicting at times, and rapidly evolving. Accordingly, when various recommendations were provided by state and federal health agencies and how they were implemented by the employers were therefore critical elements of fact that are going to have to be determined to resolve the constructive discharge claim. That, I think, is going to be a key trend line that we're going to see through these cases as they develop and go through the court system. Where were you in time? What were the recommendations at the time? If a company wasn't following them, could that be considered negligence if then 2 months later they were rescinded in favor of different types of guidance or regulations? I think it's going to be a morass. And the end result of that is, if you're in litigation, is that it's going to be harder to get these cases out on summary judgment. You're looking to, well, maybe a jury has to decide this issue. So in one respect, it's a welcome development for employers because you do have some consideration from the courts as to what they were going through. But in another sense, more difficult to get out of the case at an early stage. And that's can be difficult for employers. All right, and finally, in addition to tracking and categorizing legal issues themselves, we also try to categorize COVID-19 filings by the factual circumstances that characterize the complaint. And what we're seeing is that termination, as I just described, termination facts, circumstances are what drive most of the complaints. And so people get fired, and that's when they start to sue, and often it will relate to something COVID-19 related. The alternative, and we'll see this a little bit later, is that RIFs and furloughs have also been a big concern during the pandemic. Those are not as big of a driver of litigation. All right, let's go to the next slide. All right, so now let's talk about the individual industries within this industry group. Let's talk first about the logistics companies. Those companies had the largest number of lawsuits filed against them by far when you're considering companies in this group. The types of lawsuits filed have been dominated by workplace safety issues, to a lesser extent by discrimination cases. And some common themes that we're seeing is that people were claiming they were fired after they complained about COVID-19 precautions. And some of those relate directly to issues that you see in the logistics industry. For example, I'm thinking of a case where a person complained that the vessel that they were using as a shipping vessel hadn't been properly cleaned in between crews coming in and off that vessel, and that gave rise to a lawsuit. We haven't seen a large number of wage and hour cases in this group like we're not seeing in a lot of places due to COVID-19, but I would say there's relatively more here than in other industry groups, and so that's kind of interesting. California and New Jersey led the pack in terms of filings against logistics companies. Let's go to the next slide. All right, airline and rail companies are another group within this subcategory. The interesting issue here is that contrary to what I said earlier, these cases are not being driven by termination so much as they're being driven by RIFs and furloughs. And I think that that's probably a product of the fact that these companies had to almost go to a full stop spring of last year, as everyone's, travel just basically went to zero. So you did have a number of RIFs and furloughs, and then that generates discrimination, leave, and other types of claims because people think, oh, the reason I was selected for the RIF or the reason why I wasn't brought back when other people were is for this discriminatory reason and not for the economic justifications that the company would be giving. Airline and rail companies face lawsuits in states with major population centers and large airports. That's not a surprise. And with the rail companies, to Carla's discussion earlier, we're seeing a lot of labor-related litigation in the rail industry. All right, let's go to the next slide. All right, now let's talk about transportation and gig economy companies. Here we're talking about a handful of cases, and we're talking about defendants like Uber, Lyft, DoorDash, Postmates, and others. And with respect to these, I would say these cases are fighting a COVID-related battle, but really it's in the last war, the larger war that these companies are facing, and that is, are they employers of these drivers or are they not? And so a lot of these cases allege that they weren't allowed sick leave because of the pandemic, or that the employer didn't institute safety protocols. Well, those obligations only arise if they're employers of these companies. And so what you're seeing, what we tend to be saying, is that this is just an old argument, an important argument, very important argument, but an old argument in new clothes, dressed up with the COVID-19 pandemic. And that's kind of what we're seeing in that space. I look forward to any questions about this, but without further ado, I'll go ahead and turn it over to my colleague, Ada Dolph, to talk about biometric privacy issues.
Thank you, Matt. Good morning. I'm Ada Dolph. I'm a partner in our Chicago office, and I'm co-chair of the Air and Rail Specialty Team. And I've been following BIPA for a long time now, probably the same amount of time as everyone on this call, but I wanted to give you an update. It remains a credible threat for fairly extensive litigation for all companies that operate in Illinois and elsewhere and have some Illinois connection. I'll also give you a quick legislative update on some attempts to amend BIPA that ultimately were unsuccessful this past session. Seyfarth has been working very closely with the Illinois Chamber of Commerce on those efforts. I can give you kind of an insider's view of what happened there and what we're continuing to work on, as well as copycat legislation that we're seeing across the country. Next slide, please. So I won't go too far into BIPA. The Illinois Biometric Information Privacy Act is the full name of the statute, because I'm sure many of you are familiar with it. I'll note that it was enacted in 2008, but it really didn't start to gain traction until 2017, when we started to see an onslaught of lawsuits filed over biometric timekeeping. That is, timekeeping that uses a fingerprint or finger scan for punching in and out. That's where it started, and it's evolved from there. Next slide, please. The Illinois Biometric Information Privacy Act, as I'll touch on a little bit later, is unique in that it allows, as compared to other states, a private right of action. It's also very broad in who is covered. And this, I think, was lost on most employers, including the Illinois Department of Labor, when it was enacted in 2008, because it was very focused on consumer use, or use of consumer biometric information as compared to employee information. But if you look at the definition of who's covered, it's very broad. It covers a wide range of private entities. The only exemptions under the Illinois BIPA law are certain financial institutions and certain government agencies. Next slide, please. There are some exemptions, and I'll touch on in just a minute. Some of these are being litigated very heavily right now. It doesn't impact the admission or discovery of biometric identifiers in court proceedings, and it cannot override certain Illinois and federal statutes that are listed here on this slide. The most significant one that's being litigated as we speak is the HIPAA exclusion that you see there listed, and I'll talk about that court challenge in a moment. Next slide, please. So again, BIPA is notable for its breadth. So it covers biometric identifiers. These items listed here squarely fall into what a biometric identifier has been interpreted to cover, particularly at the early motion to dismiss stage in these cases. And if you're using any of this kind of technology, you should count on BIPA being applied. That's a retina or iris scan, a fingerprint scan, voice print, a scan of a hand or face geometry. Next page, next slide, please. It does not include a few things by the letter of the statute here, but there has been some debate and some case law that has drained these exclusions. So for example, the biometric identifier supposedly excludes photographs under the letter of the statute. However, courts have concluded that if a photograph is used to derive a face scan, that would be covered by BIPA. Those cases haven't, in some cases, gone to summary judgment. They've resolved before those issues have been decided. But just things to note is that you need to understand where the courts are at in interpreting the statute at any given time. You can't necessarily rely on, just a plain reading of the statute. Next slide, please. The other thing is that, of course, it has a catch-all. So even though it's got a list of what's biometric information, it also has a catch-all that says anything based on an individual's biometric identifier used to identify an individual. So very circular there, and certainly this has been leveraged in instances where there's been arguments made that the fingerprint scan, for example, for timekeeping has been converted to a numeric algorithm and is not, in fact, retained as a scan of the fingerprint. So these are the types of things that make this a difficult statute to defend. Next slide, please. So what does BIPA require? And again, I don't want to belabor these points because I know many of you are familiar with this statute. First, you need a written policy that governs the collection and retention of biometric information, and in some nuances that perhaps reflect the time period within which this was enacted. That policy is supposed to be available to the public, and you need to comply with your retention guidelines. Next slide, please. Some of the most highly litigated portions of the statute include this one, which is that you may not collect, capture, purchase, receive, or obtain a person's or customer's biometric identifier or biometric information unless you first inform the person in writing that you're going to be collecting or storing it. You can also inform the subject's legally authorized representative, and that's been a key component of some preemption arguments under the Labor Management Relations Act and the Railway Labor Act, which I've argued that have been successful in defeating these claims. You also need to receive a written release executed by the subject of the biometric identifier or that person's legally authorized representative. Next slide, please. Writ release, again, it's got some antiquated and sort of ambiguous language that suggests that in the employment context, a release must be executed by an employee as a condition of employment. This doesn't make a lot of sense because it certainly would potentially require an employer to terminate someone who fails to agree, but that is frankly not how we've been advising employers to comply with this piece. We've been focusing on obtaining a written consent. Next slide, please. You also may not profit from the use of biometric information. So that's outlined in Section 15C of the statute. Next slide, please. Section 15D of BIPA has been heavily litigated in the context of whether a plaintiff has Article 3 standing to proceed in federal court, which is where defendants have been preferring to take these cases so that they can have a more rapid review of the statute, interpretations, and potentially higher likelihood of defeating the cases on summary judgment or early motion practice. But this provision involves dissemination of the biometric information, and it really has focused in practice and litigation on the transmission of, for example, biometric fingerprint scans used in timekeeping to a third party. and that's where this provision has come into play. The courts have found that this type of dissemination allegation is sufficient to state the kind of Article 3 federal harm required to stay in federal court. So many of you are familiar with the Rosenbach versus Great America case, which was up in front of our Illinois Supreme Court, where they concluded that simply allegations of any violation of the statute were sufficient to give harm for the state court proceedings to proceed. So there's a difference in the harm required for these cases to go forward in the Illinois state court versus federal court. Next slide, please. And then the information that is obtained, you need to treat as confidential, almost medical level type information. So that's another provision of the statute. Next slide, please. So the key driver of the trend of these cases, which has continued unabated since it really picked up in 2017. I would say there was a slight lull during the COVID pandemic, but we're seeing these continuing to come out. Basically, anytime a technology is being used that could fall under the very broad provisions here, you're at risk of being sued in these cases for this reason here, which is the enforcement provision. So BIPA allows a private right of action. It allows extensive recovery to a prevailing party, although I would say there's some ambiguity in the way the statute is written as to whether that applies to both plaintiffs and defendants or not. My interpretation is prevailing party means both, but it authorizes these fairly massive statutory penalties, and there remain a number of ambiguities in the law that allow these penalties to be multiplied over many, many employees. So it's $1,000 or actual damages, whichever is greater, and $5,000 or actual damages, whichever is greater for intentional or reckless violations. There continues to be debate, which I'll get to in a minute, over which statute of limitations applies here, 1, 3, or 5. Of course, defendants are pointing to a 1-year statute of limitations, but BIPA itself does not contain one. So, of course, when you're having settlement discussions, the plaintiff's bar is arguing for the maximum here. There's also debate about what constitutes a violation of BIPA. Do you get this penalty for every finger scan of an employee 6 times a day in and out for punches for breaks or lunch, or is it per person? And those are also being litigated. Next slide, please. I'll note that recently, another factor that's driving the litigation under the penalties provision that we just talked about is, we've heard recently the Rosenbach versus Great America case, which was allowed to proceed by the Illinois Supreme Court, recently settled for $36 million. The Facebook settlement of these cases, which ended up being $650 million, a very eye-popping number, is driving continued interest by the plaintiff's bar in these cases. So what should you do if you're using any of this technology or considering using any technology that could be viewed as collecting biometric information? So certainly this is not limited to timekeeping. During the really throes of the COVID pandemic, we were advising lots of clients on temperature scanners. Would that constitute biometric information? There was various technology that would use facial recognition software in connection with temperature scans, and we were advising clients regarding the risks around that, and those are very real risks here. I also have advised clients who are considering implementing new technologies in Illinois, but really have declined to do so because of the threat of litigation under BIPA. So what should you do if you're going to implement a new technology that could be covered by BIPA? Here's a few points. The first is to really understand the technology and test it for yourself. There are times when even vendors themselves don't understand the nuances of BIPA or have concluded that and may represent to you that it's not covered by BIPA. That is something you should explore for yourself. There are times when the technology has features that could collect biometric information, and the vendor is saying it's shut off. You need to understand what that means. Because if it's not fully shut off, if it's even perceived, frankly, as collecting that information, you're at threat for a Biometric Information Privacy Act lawsuit. Understand your vendor. Look at the contract with your vendor. Make sure you've covered how you're going to share liability around these issues. Make sure they are doing things to protect the data consistent with BIPA. If there's any risk of BIPA exposure, you'd rather be on the side of already having complied. And then lastly, just insurance coverage, which remains an area of debate. Early on in the cases, insurance companies were arguing there were exclusions that applied. We've seen that swing back and forth, and for the most part, the courts have found that certain policies do cover this, but this would be something you'd want to investigate with your insurance coverage to make sure you have adequate coverage in place, given the size of the penalties and settlements associated with these cases. Next slide, please. So I'll touch on some of the court challenges that are happening right now in this area that we are watching very closely. There's been a number of additional preemption arguments that have been made after the successful Railway Labor Act, and then following on that, the Labor Management Relations Act preemption arguments, which essentially argue that the collective bargaining agreement, and in particular, typically the management rights provisions of those contracts, govern the terms and conditions of employment and preempted any outside challenge to those under state court law, and instead put those into the arbitration or grievance process outlined by the CBAs. So currently pending is another preemption challenge, the Illinois Workers' Compensation Act, whether that preempts these claims. So far, the defendants that have been making these arguments have not been successful, but they are presently up on appeal in front of the Illinois Supreme Court to determine. So we are watching that very closely. The next one I wanted to mention is, again, there's a lot of debate over which statute of limitations applies. There's a couple of appellate courts that are considering right now the 1, 2, or 5 year statute of limitations. And so we're watching those closely. Those will deeply impact the settlement negotiations and, you know, whether you proceed with prosecuting or defending these cases. Next slide, please. And again, given the statute sort of sat idle for almost 10 years before it started to be interpreted, we're just now seeing interpretations of its provisions. So the first one here on this slide is, again, evaluating when a violation occurs, which is directly related to how the penalties are assessed, which can be, as you can imagine, you know, if it's 6 times a day a violation occurs versus 1 time per employee at the point of initial collection, that's a vastly different damages calculation. And that is certainly, in my experience, playing a role in whether these cases settle or proceed through a litigation process. Another exclusion that's being litigated right now, I'll mention here, is the HIPAA exception for certain healthcare providers. Whether that HIPAA exception covers employees who are performing or having biometric information collected as part of the operations of the healthcare provider facilities. So again, we're continuing to see interpretations. We're seeing very aggressive litigation early in these cases because, as I mentioned, many employers were sort of caught flat-footed over this. And so many of them, by the time the lawsuits have filed, are starting to look at just compliance with BIPA, even if they are not sure it would be viewed as applying, but there's a past period of time, particularly if the statute of limitations goes back 5 years, that is not covered. So we're looking at lots of preemption and other aggressive defenses. Next slide, please. I'll just touch on that this past session, there was some attempts to amend BIPA to clean up some of these ambiguities and issues that we talked about. They were not successful. They got very close. So I was privileged to testify in front of the Judiciary Committee of the Illinois House, and it did pass out of committee. It went through a number of iterations. Here, if you'd like to review, are some of the proposals that were made to change it and amend it and kind of clear up some of the issues that are causing the uncertainty in litigation and driving these big settlements. Notably, the near final version did have that the Illinois Workers' Compensation Act would not preempt these claims. So that was a significant clarification that was going to be coming from BIPA. But in exchange for that, there was going to be all these other provisions that you see here that would be more helpful. Next slide, please. And so we'll continue to monitor this, of course, but the only other couple of states that have something similar to BIPA are Texas and Washington, and they do not have a private right of action. Those statutes are enforced by the state's attorney general, and we've seen very little enforcement activity there. So when we see provisions for adopting similar legislation, they typically are now including a private right of action and very closely modeled on Illinois' BIPA. So South Carolina proposed one in 2019. Most recently, the New York Assembly proposed, the only change they made really from BIPA was they took out information, so it's the BPA instead of BIPA. It's very closely modeled on BIPA. So we're continuing to watch these developments, but you should as well. If you operate nationwide, have a connection to Illinois, obviously watch what's happening in the BIPA sphere. But if you operate in any of these other states or employing technology, you should be watching these developments very closely and advocating around these issues as well. We saw very successful advocacy happening, although not ultimately successful in the Illinois context, where the arguments, very legitimate arguments are being made about the stifling of innovation and technology in Illinois because of the threat of the scope of this BIPA liability. And with that, I'll turn it over to Andy.
Thanks, Ada.
Hold on, Andy. Sorry, before we, I need to interrupt here for just a second. I do want to remind everyone that the Q&A chat or the Q&A buttons are available. So if you have questions for our fantastic panelists, please start adding them in now. We're going to try and take a few questions at the end. And just wanted to read out the CLE code. For those of you that are looking for that, it is SS, as in Seyfarth Shaw, 8392. So once again, SS 8392. And now I'm turning it over to Andy because this is probably a topic on everybody's concern list. Let's leave it at that. And Andy, take it away.
All right, thank you. Spoiler alert, it ends with a cliffhanger. So I'm a partner in our Chicago office, and I focus on class and collective action litigation and also deploying arbitration agreements to avoid those kinds of claims. If we could go to the next slide, please. You know, we've seen federal, state, and local governments take some unprecedented actions in response to the pandemic, and some of those actions have been focused on boosting the economy. Typically speaking, infrastructure spending is one of those areas of government action that's pretty popular across the board. So it's not surprising that one of the early priorities from the Biden administration is to put some infrastructure spending and planning at the top of its list of priorities. So what we saw is that the administration put its first stake in the ground in March, and its initial proposal was to spend $2 trillion over the next 8 years, which it would pay for through a corporate tax increase. And you can see on the slide what some of the priorities were for the administration. There's the traditional infrastructure spending categories like roads and bridges and ports and airports. But they also wanted to turn attention to things like our utilities, making sure that there's clean water, there's a strong electric grid, bringing broadband across all parts of our country, and then investing in other areas that aren't maybe traditionally thought of as infrastructure, like caregiving, modernizing homes, and then the sort of tag on that nobody could oppose, right, of revitalizing manufacturing across the country and focusing on making products in our country. So let's go to the next slide, please. Here you can see some of the areas of spending that are more specific to transportation infrastructure that were included in that initial plan. You can see that the biggest category actually was investments in the electric vehicle market. Pretty significant amount of that money is intended to spur the putting in place more charging stations so that people who might be interested in electric vehicles but are concerned about their ability to travel feel more comfortable that they'll be able to stop and charge their vehicle when they need to do that. But they're also, they propose major investments in roads and bridges, public transit, railways, again, ports and airports, finding ways to put more investments into neighborhoods that have been cut off by previous investments in infrastructure. So, you know, areas that have been cut off, say, by highways, reconnecting them to their communities. And then some of the money also was intended to address climate-related issues and making our infrastructure better able to respond in the event of a climate-driven emergency. So let's go to the next slide. The problem, of course, even though infrastructure spending has bipartisan support, the devil is always in the details. So as we've seen, there are challenges to getting a bill passed. Almost immediately, there were objections to the administration plan because it included things that aren't traditionally thought of as infrastructure. Now, the plan was titled the Jobs Plan, so I don't think it was necessarily intended to be infrastructure only, but it did change the conversation around. What we saw from the Senate Republicans in their first counter was a plan that was worth about a quarter of what the administration had hoped to achieve. That did prompt, though, the administration to revise their proposal. So they came in at a more modest $1.7 trillion, still a very significant number, but it was a non-starter in the Senate. So what we've seen since then are different splinter groups trying to find some areas where they can agree. So we saw, for example, some senators come together around a deal that would just put money into highway improvements. Again, that hasn't passed the Senate, but we saw them organize around that. Then we saw other splinter groups trying to see if they could reach broader plans that were more targeted. So just within the last couple of weeks, we saw this group of Republicans, just Republicans, led by Senator Caputo of West Virginia, who had a pretty significant plan that they offered. It's about half of the initial plan from the administration. But a lot of that money, again, is directed into that traditional infrastructure spending. So transportation infrastructure like roads, bridges, airports, rail, ports. However, though, that only got Republican support, mostly because they didn't want to pay for that with tax increases. I think that the Senate Republicans view the tax cuts from the last administration as sort of a key win for them and something they don't want to revisit so soon. So that's been a real barrier to reaching an agreement. Democrats have tried to meet them by saying, well, instead of increasing taxes, maybe we increase enforcement. But so far, that's not going anywhere. So conversations with that group of Republicans and the administration ended. But what we've seen very recently is a bipartisan group of senators, and actually, when I wrote the slide, it was 10 senators, but now it's a larger number. We've now got 11 Republicans and 9 Democrats who have a deal. It's worth about half of what the administration initially proposed. The details are very thin. They haven't put out the kinds of, lengthy descriptions that we saw in the earlier stages, but it's about half Republicans. There are 11 Republicans and 9 Democrats, and there seems to be a little bit of momentum growing there. So perhaps things are a little more optimistic than I thought when I put this together. So let's go to the last slide. So what's next? We've seen already some smaller bills get passed, usually by calling them something other than infrastructure and kind of avoiding this debate. So the U.S. Innovation and Competition Act was passed very recently, and in large part it was framed as a response to China and a way to stay competitive with China, but it did include investments in things like microchips, right? So it could be that we're going to see more smaller bills where somebody gets creative, finds an idea or principle that everyone can rally around, but that also includes some money that will go into infrastructure and other ways to stimulate our economy. It looked like we were unlikely to reach any kind of far-reaching bill. Well, certainly by the original target date, congressional leaders had wanted to have something passed by July 4th. That seems unlikely. But this more recent bipartisan group of senators suggests that maybe there is some hope to get at least part of the administration's plan accomplished through legislation that gets votes from Republicans and Democrats. You know, whether that happens or not, or whether there are still some gaps to be filled, reconciliation is an option. Reconciliation is a process where items that have impact on the country's budget can be passed with a 50% vote, right? 50 plus 1, so it can't be filibustered. It's something that the internal Senate rules only allow to be used a limited number of times, but I understand there are investigations whether they might be able to deploy that again later this session in order to get something passed. But what it looks like is, despite the administration coming out very early and pushing for spending in these areas, the real action, if there's going to be any, is probably going to be later in the summer or early in the fall. And the exact nature of what that will be still remains up in the air. So with that, Aaron, I will pass it back and open things up for questions.
So much, everybody. Really appreciate it. We don't have a lot of questions, but there is one that wants, and I just want to confirm that yes, all of our participants this morning will be receiving a copy of the program, both the recording and the slides. And with that, you will be receiving a certificate to send back so that you can get the CLE certification. And once again, that code for those of you still participating is SS, so Seyfarth Shaw 8392. And I'll just give everybody a minute here to see if there are any other additional questions that come in. And want to thank all of our speakers for being some in the office and some virtual this morning. We are hoping as the year progresses and we open back up that we may be able to see all of you live and in person again. But if not, we'll continue to do them virtually because I think everybody seems to be enjoying that. Seeing no other further questions coming in, I'll say thank you once again to all of our fantastic panelists and wish everyone else a great day and a great rest of the week. Take care, everyone.